Hello everyone and welcome to today's webinar. We've got a great presentation lined up for you today, but before we get started, there are just a few general admin points to cover. First and foremost, please use the online question tool to post any questions that you have and we will share them with our speakers. Second, if you experience any technical difficulties today, please let us know using that same questions tool and a member of our admin team will be on hand to support you. And finally, just to note, this session is being recorded and we'll be sharing a copy of that recording with you in the coming days. So, without further ado, I'd like to hand over to our speakers to get us started.
Great, thank you. It's lovely to be here today in conjunction with Lexology, talking about the UPC. It's been a long time coming, and I think we've got a few things to cover today. So we'll move swiftly on. Just to introduce ourselves, we're from Bristow's law firm, a full-service law firm that advises clients in all sectors, but particularly those in the tech sectors and life sciences industry. My name's Claire Smith, and my fellow colleague is Ellen Lambrix, and we're from the commercial IP transactions team. And today the talk, I think many people have seen quite a lot of literature and commentary online and in various places about the UPC, with a big focus on patent prosecution and litigation, which is what the UPC is all about. But we're coming from it from the emphasis of how this impacts on commercial agreements and any type of agreement really where IP is created or transferred or licensed. So just as an outline of our agenda today, we're going to do a short introduction to the UPC and the Unitary patent and talk about some of the key concepts and features about the new system that's coming our way, and particularly about opting out of the system, and talk about some of the key strategic considerations that parties and people will have when looking after their patent portfolio or deciding whether to be in or out of the system. We will outline those key considerations. And then we'll move swiftly on to their impact on agreements and key provisions to consider from different parties' perspective in agreements and things to watch out for, including things like considering the risk of essential revocation, which we'll come on to, which is a big feature of this system. And then we'll talk about the new Unitary patent and how that's dealt with as an asset, and about some specific issues that are drawn out in the new system which relate to co-ownership. I think just as a bit of housekeeping, please do ask questions in the chat. We'll try and deal with them along the way. If we don't, we'll try and deal with them at the end. And if we still don't get the opportunity to answer those questions, then they can be forwarded on to us, and we will try and answer them after the session. So I will now hand over to Ellen.
Thank you very much, Claire. So we're going to start the session today just with a very brief introduction, talking about what the UPC actually is and what Unitary patents are. Obviously, we kind of need that basic understanding before we get on to the more detailed stuff in the agreement. So the UPC and the Unitary patent, really it represents the biggest shake-up in European patent law in decades, and as Claire said, it's been a long time coming. But what is it? Essentially, the new Unitary patent is it's a new type of patent which is going to provide unitary protection in up to 24 of the EU member states, and this is all going to be administered centrally through the EPO. So you get protection in all of those the member states that are participating in the Unitary patent through that one application. And the objective then is to really kind of complement the centralised procedure that you have pre-grant for European patents with then a centralised procedure post-grant, and that needs administering with a new court, and that's where the Unified Patent Court comes in. So this is the new international court and court system which has been set up by the participating EU member states, and the court is going to deal with both infringement and validity issues of both the classic European patents and then also the new Unitary patent. So the aim is it's going to help hopefully streamline patent enforcement in Europe, potentially be a simpler, quicker and harmonised central system. So the aim to avoid having parallel litigation in lots of different courts across Europe. And also the big thing is that you, as a patent owner, potentially can get a European-wide injunction. I won't go into too much detail about the territorial scope. There are some notable exceptions. All of the countries need to be EU member states. So obviously now post-Brexit, that rules out the UK, but also, for example, Spain is not in the system because of some disputes about the language issues, I think. And then where we are in terms of timing, it feels like we've been waiting for this for a long time, but it does sound like it is now really going to be happening. So I think we're expecting the new system to come into force early next year. And before that, there's going to be a what's called a sunrise period of 3 to 4 months, which runs from the date that Germany ratifies the UPC. And essentially that's going to happen once the UPC committee is satisfied that the court is ready to be operational. And so, because, as I said, this is such a kind of shake-up of the system, there is going to be this transitional period of time, which is going to be initially 7 years. Potentially that might be extended for a further 7 years, and I imagine actually it probably will be extended. And during this transitional period of time, if you're the owner of a classic European patent, you're going to be able to opt them out of the UPC system. And Claire's going to come on to touch briefly on some of the reasons why you might do that. And if you choose to opt them out of the UPC system, you can do that for the entire lifetime of the patent, and that's unless an action has already been brought at the UPC. You can then subsequently withdraw the opt-out, so essentially go back in again unless an action has already been brought before a national court. And then also during this transitional period, infringement and revocation actions for classical European patents can still be brought before the national courts. And then we're going to talk quite a bit about opt-out and rights to opt-out later in the context of contracts, but it's kind of important to understand when you're thinking about the rights to opt-out, actually who has the right to request an opt-out from the UPC system of a European patent. And as you can see, put on the slide there, it's only the proprietor of the European patent that can request the opt-out, and importantly, not a licensee. So we'll kind of get on to why that's important to look at in your contracts later.
So thanks, Ellen. Just to pick up on what Ellen was mentioning earlier about the Unitary patent, effectively a pan-European patent that doesn't cover all the member states, but those which are participating in the system. So you've got a single asset that covers a sort of a wide jurisdiction. That's an option that people may favour. We set out on the slide here the pros, it's the main pros and cons of going for a Unitary patent. And I won't go through all of them, but obviously it's more sort of simple to administer, and actually there would be quite potentially very large cost savings to be made rather than going for separate EP patents, for instance. I think generally, rule of thumb, it's generally thought to be less expensive to set up a Unitary patent rather than going the traditional route if you want protection, at least for European countries. But as UK, for instance, is outside of the system, you'd have to separately validate your European patent in the UK, so that's an extra cost. So, you know, you'll have to look carefully at the cost savings. The cost savings could be quite substantial for quite a long time, but you have to remember that with the tradition, it's an all or nothing approach. So once you have your European patent, you can't drop countries later on. You have to either drop the whole thing or not. And so currently, when people have a collection of patents, they can prune their portfolio to, as time goes on, for countries which aren't of interest anymore, to reduce your cost. But you can't do that with a Unitary patent. So you could end up at the end having more costs than you wanted to start with. think the other big thing to mention is the risk of central revocation. If somebody wants to challenge the validity of your patent and it's a unitary patent, then basically if it falls down, if the whole thing falls down and you don't have protection in any of those countries. And the UPC system is mandatory, there's no opting out if you get a unitary patent. So just briefly on some strategic considerations about whether you want to apply for a unitary patent and or have your traditional classic European patents in this system. I'm going to just sort of outline some of the key considerations, but I think it's important to stress that if you're a company or an organisation looking at your patent portfolio, you need to sort of develop at least a basic strategy. Are you going to opt all of them out? Are you going to opt all your EPs in, or are you going to select a different approach, maybe on a product or portfolio by portfolio basis? I think the key factors that come into play, the territorial coverage, as I mentioned, about how much protection you want across Europe and whether it would save you costs, for example, going with the unitary patent. There's also how likely are you going to litigate these patents? Do you want that pan-European enforcement and be in the system? Whilst there's some other European countries are still out of the system, that might not be so attractive. And maybe if you're only going to litigate in a couple of countries, that's actually more cost effective than a pan-European action. I think the biggest thing, as I mentioned before, is this risk of central revocation. It applies not just to a unitary patent, but if you have a classic EP patents opted in or not opted out of the system effectively, then a challenge to your EP patent in Germany will, the designation in Germany will, that was successful, would wipe out those patents in all the other countries in which the UPC applies. So some people think, well, I'm not willing to take that risk, even if the cost savings might be beneficial. I think it will depend from organisation to organisation. Small companies may not want to take that risk. They might, especially if they only have one or two products or technologies that completely rely on that patent portfolio, and any wiping out that portfolio would be devastating. Investors as well might think that that's a high risk strategy as well. Tech companies, for example, may be a bit more relaxed, particularly if they're not really planning or in a sort of market where their patents are often litigated, might feel a bit more relaxed, especially if they only want to get patents in 3 or 4 countries. In the life sciences industry, I think there is a mood that most life sciences companies are thinking about opting out, or at least their most important patents to opt out. For example, if you have a drug compound patent, which is absolutely key, you might want to keep that out of the system until you see how things pan out. But you might want maybe some other patents, for example, for the formulation of a product, or some manufacturing patents where you might be a bit more relaxed about trying the system with those. There are some patent filing strategies about divisionals, etc., where you keep some things in, some things out. I think from a transactional perspective, where we're largely coming from today, is what is your licensing strategy? If you're planning to license out your patents, does it make a difference whether you have a patent in a particular country? If you are getting a royalty stream, which is reliant on a patent being in a country for you to get a royalty for sales in that country, you might be very wary about having a central revocation, which would mean that your royalty stream would be cut off not only in that country where the challenge is initiated, but in every all the other European states that are part of the UPC. But if you have for example, a licensing strategy where somebody just pays an annual license fee, which isn't dependent on where or exactly how many patents you have, then you might be more relaxed.
Okay, thanks, Claire. So kind of moving on to the kind of meat of the session now. So thinking about actually what is the impact of the UPC and the new unitary patent on particularly licensing and collaboration agreements. So as Claire was kind of outlining there, it's going to be important for any company who has a patent portfolio in Europe or is a licensee of patents in Europe to have a patent strategy, and it's then important to make sure that any agreements that you have under which those patents are licensed, or if you've got R&D agreements when new patents are being developed in collaboration with third parties, that actually all of your various contractual arrangements relating to those underpin and really support your overall patent strategy that you're going to be taking with the UPC. So when you're looking at your agreements that you have in place, your relevant agreements, you're going to need to look at the drafting and consider the implications of what you've got in your existing agreements for both the traditional European patents, and then thinking in particular about things like rights to opt out, and then also how the provisions will apply to any potential future patents and the ability to apply for a unitary patent. And once you've looked at those existing terms, you might consider in this period of time that we've got now before the court goes live, actually, whether there should be any changes made to the terms that are in the license agreement, actually what the impact that's going to be on your property rights. So thinking about, just very briefly, the unitary patent, as you mentioned at the start, this is a new type of patent. In terms of licensing unitary patents, actually, it's really quite straightforward. There's not much change you need to think of actually in terms of the license grant provisions themselves. Although a unitary patent, as we've said, is a unitary right across all of the participating territories, and that means, as we'll come on to later, that you can only transfer those rights for all of the territories. Actually, for licensing, you can grant a license with a territorial or a field restriction. So you could, as a licensor, grant a licensee a license in individual territories covered by the unitary patent, and then you can grant both exclusive and non-exclusive licenses.
We're having a poll.
Yeah, yeah. Before we get into this, we thought we'd liven things up with a poll. So hopefully on the screen you'll see a poll here. So we were just interested to know, in the licensing and collaboration agreements that everybody attending has seen over the kind of last 5 years, roughly how many of them actually expressly address the UPC? So you'll see some options there on the screen. We'll just give this a minute, I think, for everybody to get their votes in. Oh, there we go. That's really interesting. So yeah, hopefully you can all see the results there. So I think it really shows that the overwhelming majority of you in your kind of license and collaboration agreements, actually, they don't expressly deal with the UPC. And I think that's quite consistent with the experience that I've had. I don't know about you, Claire,
very similar. I think there was maybe an appetite about 5 years ago, 6 years ago, where some people were adding this into their agreements and dealing with it, and then I think because things stalled again, that people went off the boil. So yeah, I think that matches our experience. It's really good to see that, that people have got similar experiences.
Yeah, and so that's interesting, really. Then when you're going back to look at your existing agreements, really there's a process to be gone through, because obviously the agreements, for those that are in force, if they don't deal expressly with the UPC and unitary patents, there's a process of interpretation that you need to go through. I think we'll come on to that a little bit later. But so these are things that you need to be considering now, particularly if your current agreements don't address these points. And then also, obviously, these are all points that you need to think about for the future when you're negotiating new license and collaboration agreements. So I was just going to focus just for a moment on the patent prosecution and opting out classical European patents. And obviously it's a significant decision as to whether or not you opt out any one patent. As Claire touched on earlier, there are various pros and cons of being in the system. And as I mentioned, it's the owner of the patent, the proprietor, who has to lodge the opt-out. And so there's no ability for a licensee itself to opt out or withdraw an opt-out. And but it obviously exclusive licensees have got a really significant interest in actually in the strategy over this decision. And an exclusive licensee is often going to want to be able to influence or actually even control those decisions. And so, I mean, particularly in the life sciences sector, an exclusive licensee will normally insist on controlling actions against infringers. And so, sorry, so and I kind of, as we've seen from the poll, most agreements don't seem to deal with the UPC in their current terms, and so the prosecution provisions that you've got in there might be inadequate. So now is really the time to think about whether those agreements need to be amended to address the UPC. So I'm kind of on the slide here some things that actually you will want to consider in terms of approach. So you might agree an approach where the licensee and licensor will just agree to cooperate on making a decision, or actually you want to opt out as the default. Maybe you want to agree a strategy up front, whether you're going to opt out and when. And if you're a licensee and actually you want to have control over that decision, as I said, you don't actually have the right to lodge the opt-out. So how are you going to do that in practice? Hopefully the licensor cooperates with you and will opt out on your behalf, but do you want to back that up with a power of attorney from the patent owner? Obviously the patent owner might resist that. But you're certainly going to want some strong further assurance provisions in your agreement.
Great, thanks, Ellen. So some practical examples. We put so paraphrase some typical license wording on the slide here about some of the things you might typically see in agreements. And for example, here is one where the licensee, most likely an exclusive licensee, has the responsibility for prosecuting, filing, maintaining the patents at his expense, and consulting the licensor, i.e. the patent owner, about those kind of decisions. And the question is, with these kind of clauses, can the licensee actually opt out on the basis of these provisions? I think the trouble is that as opting out is something that is not, even though it's an administrative task of opting out, it's not actually something that is necessarily solely linked to prosecution of the patents. It's actually about what courts are you going to use if you're litigating the patent. So it's actually an enforcement and a litigation question, and one of jurisdiction, rather than actually just a matter of patent prosecution. So these clauses will not necessarily give a licensee, it might see that the licensee has overall control of the patent matters under the license, but actually this clause might not be effective enough to let it do that. And it's also a question of contract interpretation, so you'd have to look at that clause, you look at the clauses where it says which party can sue infringers, and those kind of rights and responsibilities. But ultimately, if your agreement doesn't deal with the UPC expressly, you'll probably find that it's not clear and the licensee doesn't have any right to insist on an opt-out. And as Ellen said just now, it has to be anyway in practice the owner, the licensor, is the only one who can opt out. So the licensee would have to have a clause in there saying that the licensor would have to affect the licensee's wishes and do an opt-out for it. I think if you are, I mean, this is looking at existing agreements, but these issues equally apply if you're negotiating new agreements. Also, if you're, if you put the shoe on the other foot and you're the licensor, you might want more of a say. I mean, this clause will not necessarily tell you about whether the licensee has the ability or not to file for a unitary patent, as opposed to a bundle of EPs, for example. There may be clauses in there that talk about the licensee having sort of final decision-making rights about geographical coverage, in which case it's most likely that the licensee will have the ultimate decision-making power about whether to apply for a unitary patent. But as a licensor, that might be a concern to you, for example, the potential revocation issue. And so as a licensor, you might be interested in changing these clauses so as to protect your interests, so that you are consulted or even have approval rights over any decision to file for a unitary patent. And then in the reverse situation, you might see these types of clauses where the licensor has the control under the contract, and they will consult the licensee, and you might want specific wording in there that they will consult you, not just about sort of filing, prosecuting and maintaining, but also the decisions to opt in or opt out or withdraw the opt out as the correct terminology, and whether the licensor applies for unitary patents. So it's all very important to open a dialogue. It's also very important if you're a licensor and you have multiple licensees that actually these things are in your control, because otherwise you're going to be dictated to by several parties and might be in a conflicting situation. And here's some example wording that if you're, for example, the licensee and you've agreed that that's going to be your ultimate decision about opting out, this is some wording which would protect the licensee in that situation to make sure those wishes are carried into effect, and that the licensor shouldn't be doing any opting out behind the licensee's back, basically. So that's an example clause. Just moving on, there's the situation of co-ownership. So if the patent is owned by 2 or more parties, then all the proprietors need to lodge the opt-out. So you might be in a situation, for example, in a collaboration agreement where you've generated some patentable subject matter, you've got maybe a jointly owned patent, and you will need one co-owner will need the cooperation from the other co-owners. So it's a bit very similar to the situation of a licensor or licensee. Have a strategy with the other co-owners, have who will have the ultimate decision-making rights if you can't agree on opting out. Maybe the default is to opt out, or maybe the party that's paying for the prosecution or has the greater commercialisation rights would ultimately have the say. But you need to consider how you sort of affect those decisions and what sort of governance you have to make those decisions, whether that's actually written into the contract, or whether at least you might want something that's discussed in that nature as part of a sort of joint steering committee for patent prosecution. I think the other issue is this is not just about unitary patents, as we said, it's about split ownership of EPs. So if you have an EP where you've got a German designation and a French designation, and then you have them in different ownership, then the 2 owners have to coordinate to lodge an opt-out. And so that might not be such an issue if they are just part of the same group of companies, then the meeting of minds. But if, for example, you are selling or assigning the assets, for example, the patents, for example, as part of an asset sale, then you need some meeting of minds or some provisions in those agreements if you're splitting up the invention and those patents across those borders, so that there is a joined up approach, even though the the assignee might have, go off into distance with the assets, there still needs to be that cooperation. Yeah, okay.
So then thinking about enforcing patents under a license, and here we're talking about this could be a unitary patent, or could be a traditional European patent which hasn't been opted out. So as we know, obviously the ability to enforce a patent against potential infringers is a key benefit for a licensee, particularly if you're an exclusive licensee. And so just to say, kind of we're talking about enforcement, obviously are talking about actions against infringers, but this could equally apply, for example, to third parties asking a proprietor for or a licensee for a declaration of non-infringement. If you're in a scenario where actually you've got multiple licensees, actually strategically it might be better for the right to enforce to be kept by the licensor, to avoid kind of piggy in the middle situation, especially if the infringers are within the same field in different countries. And as I kind of touched on previously, an exclusive licensee is normally going to want control over infringers, particularly in the life science sector, and a licensor may need to concede that. Worth noting that under the UP system, non-exclusive licensees can sue infringers, but that's only if the license agreement expressly allows that. So that's slightly different to patents. So, and then obviously you need to think about the consequences of a counterclaim. So suing an infringer and then receiving a revocation as a counterclaim. If the revocation action is successful, actually the outcome is that the patent is gone in all of the designated states. And obviously that kind of plays into the strategic things you need to think about with the opt-out if it's a European patent we're talking about. But the other things you might need to think about are how is that going to impact your license, and particularly any royalties payable. I think, Claire, you touched on this briefly earlier, but if you've lost the patent in the whole territory, what happens to those royalty payments, particularly if they're tied to valid claims of the licensed patents? Does that mean that actually as a licensor you're not receiving any royalties anymore, or the payments stop completely? Or is there a step down royalty rate, for example, if the license agreement also includes know-how? Is there no change to the royalty provisions? And that's something, I mean, can't go into the detail today, it's probably the subject of a whole extra session, but just to flag obviously that there may be potential competition law issues there if there's royalties being payable if there's no patent left anymore. And you just think about the impact on your if you have other licensees. And then just kind of briefly, I mean, some of the same things we've already thought about, but thinking about defending a patent subject to the license, thinking about as a licensor, is it going to be acceptable for the licensee to control defence of the patent? That's possibly okay if you've only got one exclusive licensee. But then again, if you're in that multiple licensee scenario where all of your licensees are going to have an interest in the outcome of the proceedings, might be more appropriate there for the licensor to seek to have more control over the revocation proceedings.
Thanks, Ellen. So our final section will be talking about the unitary patent as an asset, as an item of property. It's got some slightly unusual features which is worth mentioning because they do affect your transactions. As we mentioned before, it's a single piece of property, so you can't sell off bits of it. You can only deal with it as a whole, but you can license it in different territories. There is question about what is the governing law of a unitary patent. Now, we're not talking about the governing law that you have in an agreement that governs the contract, saying what law covers this a unitary patent and why does it matter. So firstly to deal with the law point, and then for the next slide, basically the governing law will come on to why it matters, but it will be determined by quite a complex set of rules that are in the Unitary Patent Regulation. And essentially, it's governed by, when you apply for the Unitary Patent, where the applicant for that patent has its residence, its person, or its principal place of business when it files the application. So if it's based in Germany, German law will apply, and that's assuming it is, like Germany, a participating state in the UPC. If it was a US company, for example, which isn't within the UPC set of territories, then it then defaults to Germany, and German law will govern the unitary patent. And this can't be changed. So once you've filed a patent and it's a German company that files it, then you sell the patent to a US company, it will still be German law that governs this patent. And why does this matter, Ellen? This is because the governing law determines loads of questions about how you deal with this as an asset. So what are the formalities for validly licensing that patent or assigning that patent? What are the rules of entitlement to that patent? Because they will be different from country to country, because that's not dealt with, within the UPC. Can you secure a loan on that patent? What are the rules about that? And if the patent is jointly owned, what are the co-ownership rules about actually jointly owned patents? They'll be determined by the German law or whatever the governing law is of that country, whoever was the first, whoever applied for the patent initially, rather than any other law. So I think when it comes to co-ownership, I think Ellen, you have a few words to say about that, because it can get quite complicated.
Yeah, no, it certainly can. Yeah, so thinking about co-ownership in particular, obviously many businesses and kind of academics often favour co-ownership actually as an ownership scenario. It's easy to agree, it kind of seems fair, but ask any lawyers or patent attorneys and you'll often get a different response, kind of has a poor reputation. But co-ownership is going to be inevitable in some scenarios. For example, when inventors collaborate on a project without actually agreeing ownership of the outcome at the outset, and then also, in scenarios where companies are working together, co-ownership is quite common. And I think, given how common co-ownership scenario it is, particularly in R&D collaborations, it is something which is workable. So I imagine we're going to continue to see co-ownership in a unitary patent scenario. And as Claire was just kind of walking through the governing the rules governing how you work out what is the governing law of a unitary patent, it gets more complicated if you've got more than one owner. So I've kind of set out the rules there that are in the Unitary Patent Regulation. It's a very similar process, but essentially you have to, when you have two co-owners, you look at who is the applicant who is listed first. If they have their residence or principal place of business in a participating member state, then that's the governing law. If they don't, however, then you start looking at the second applicant. Do they have their principal place of business or residence in a participating member state? If not, you go back to the first applicant and you look, well, if they don't have their principal place of business or residence, do they have any place of business in a participating member state? If not, you move on to the second applicant, and ultimately you work your way down the tree. The default law, if the answer to all of those is no, is Germany. So it's quite a complex question, and we've got a very quick poll just to spice things up and test you. A little bit of a puzzle quiz here. So here we've got, the question is, if you have a UK company and a US company, and I'm going to clarify here that neither has a place of business in a participating member state, if they jointly applied for a European patent and then sold it to a French company, which law would govern the unitary patent?
Whilst those polls are coming in, is it worth just talking about, just briefly about the co-ownership sort of?
Oh, I think we're going to get our answer.
Oh, yeah, we've got a mix.
Yeah, so and the majority going with German law, and that is the correct answer. The answer would be German law in that scenario. And we have
go through this.
We're not going to go through this at all. If you enjoy solving puzzles and working out the governing law of a unitary patent, there is a table here of plenty of examples you can use to work through with the answers in. So we'll leave that for your fun after the session. But kind of what we really wanted to highlight with this is that kind of what can seem quite an inconsequential and arbitrary decision as to who you're going to list first in the patent application, in a co-ownership scenario, can actually have quite a major impact on the rights of the co-owners of a patent. So if you're doing an R&D collaboration, you really need to agree whose name is going to be listed first for the co-owned patents. And just to kind of give an example, the one we just had there where German law would apply, it's going to be important to think about, like, for example, if a co-owner sells its right in the patent without consent of the other, that would be allowed under German law, but that's not recognised under UK law. Importantly, though, the Unitary Patent Regulation does allow co-owners to decide for themselves. Sorry, it doesn't allow co-owners to decide for themselves which laws apply, but you can, under the national laws of most participating member states, you can agree to override the kind of default rights under that law. So this is just something, again, to be mindful of when you're negotiating co-ownership.
So we're going to wrap up now.
Yeah.
Thanks, Ellen. Just with some practical tips. Have a look at your key agreements where patents are involved. Check them. Are they fit for purpose? Should they be amended? Do they support your strategy? Try and open a dialogue with your contractual partners to see if you can get on the same page with them about opt-outs and unitary patents and strategy. And start developing some of your template wording to put into contracts. And we've seen long clauses, we've seen short clauses. So you might find that it depends on the agreement, but it's worth having those in your toolbox for when you're entering into new agreements. So I think I've had a couple of questions that we've dealt with individually online, but if anybody wanted to ask any questions before we wrap up, or otherwise we'll take them offline. I think there was one, wasn't there, Ellen, actually just popped up about, well, is it, I think somebody was saying, is it worth actually just going back over all your existing agreements and having a look at them? Is it all too much trouble? I think the answer to that probably is, well, go over the key ones, as we said, and ones where perhaps if you're the exclusive licensee and you're really caring about the opt-outs, and they're probably not going to be dealt with expressly. I think it's in your interest to get those amended, unless you've got a very good relationship with a licensor, and maybe you've have a meeting of minds and already agreed a strategy as part of a sort of joint committee. If you're the owner, you have the power to refuse to give an opt-out if it doesn't force you in the licensing agreement. So you might be sitting pretty and say, fine, I don't really want to amend my agreement, but actually maybe there's a good reason for you to amend the agreement because there's a quid pro quo. Maybe you say, oh, actually, I don't want them going off and applying for lots of unitary patents without coming to me. So maybe it's worth actually, not being too difficult, and let's have a meeting of minds. But there will be scenarios, for example, if you don't think patents are, the patent clauses are in there as the safety net, but you don't really think that there'll be some data coming out of the collaboration, but it's very unlikely there's going to be patentable subject matter coming out of it, then you may say, well let's leave that one. Yeah. So I think it's case by case basis, but it's certainly good to go back over your existing ones, the most important ones, and to bear this stuff in mind when you're negotiating ones going forward.
Agree. Agree.
I think we're just about at time, aren't we,
I think
Ellen?
we are,
So thank you so much for your time. Happy to answer more questions, and we hope you found this session useful.
Thank you very much.